All rise, please. Hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. Please be seated.
Good morning. Welcome to the Appeals Court. I am William Meade. With me today are Justices Sachs and Hodgens. We'll be the panel on all of the cases this morning. If you haven't been here, or if you have been here before, each side gets 15 minutes. We have read everything. It's my best advice that you get right to the point and not spend any time reciting facts to us. We do not entertain rebuttal in the Appeals Court. With that, I'll call our first case, 23P 1345, Commonwealth versus Bogard. Mr. Coase.
Thank you. Good morning, Your Honors. May it please the Court, Matthew Coase here on behalf of the defendant, PARNEL Bogard. This was a relatively short and straightforward trial. The Commonwealth essentially presented its case by putting the complainant on the stand and then arguing that her testimony was credible. Despite the simplicity of the trial, it was plagued by several errors. All of these errors were cumulatively prejudicial to Mr. Bogard in the context of this trial because they impermissibly bolstered the complainant's credibility, and in turn, they disturbed the jury's critical credibility determinations. I am going to start with the first complaint arguments first, but I do think that it's important for me to point out that I did make an error in my brief. On page 18, I wrote that the complainant did not tell Mr. Bogard to stop or no. As I was preparing for oral argument, I found some language in the complainant's cross-examination. So I apologize to the court for that mistake. Notwithstanding, I do think that the first complaint violations in this case were significant. And I want to first start with the contemporaneous limiting instruction argument because I think that put a cloud over the remainder of the first complaint violations here. So the general case law with respect to the first complaint instruction is that it should be given every single time that the first complaint testimony comes out at trial, whether it be through the complainant or through the first complaint witness, and then it should also be given as part of the final instructions to the jury. I know that in this particular case, the contemporaneous limiting instruction was not given either before the complainant's testimony or prior to the first complaint's testimony.
The SJC has said it's recommended to be given contemporaneously, but it's not required.
I think the language...
Was one requested to be given?
One was not requested. Okay. I think that the language is that it's not a strict requirement. So I think that the court should look at it on a case-by-case basis. I've looked at the case law pretty closely with respect to the contemporaneous limiting instructions. So of the cases that we have cited in our respective briefs, there seems to be this notion that it is more effective to give the contemporaneous limiting instruction than it would be to give the final instruction.
Well, I think what is important here is the first complaint witness was the last witness who testified at trial.
She was.
And then there were closing arguments, and the judge gave a final instruction that included the limitation on first complaint testimony that you don't take any issue with the propriety of that instruction.
No, I believe that the final instruction was appropriate.
And we're to presume that the jury followed that instruction.
That's correct. I think that's the general case law. But I think when you look at it in the way that the instructions were given, again, it's appropriate to give it at the time when the complainant testifies. And in this particular trial, her testimony was given on a Friday. And then the following Monday, the first complaint witness gave her testimony, and then it came in again at the final instruction was given, excuse me.
Why would it matter for giving the instruction during the victim's testimony? What difference does that make?
Well, I think that there's a presumption that the evidence will be given substantive value, and then the jury would accept it as proof of the matter asserted, as opposed to the more appropriate value of the first complaint, which is really just more to give credibility to the victim's statements. So that's one of the things that I argue with respect to the first complaint violations. When you name people that you've given that complaint to, it's essentially the same as giving the complaint. And so when the victim, or the complainant in this case, gave her report to the jury, it was essentially the same as naming another person that heard the complaint. It's basically repeating the complaint again.
She said that they spoke to they spoke to the lawyer, and then they made a report to the police.
That was the first complaint witness's testimony, if I'm remembering correctly.
I mean, is that what you're taking issue with?
Well, I take issue with, again, the jury instructions, and then I take issue with the naming of the two people. So you're right, they said that we called a lawyer friend, and we kind of got advice, and she told us how to proceed.
And in neither of those instances was it disclosed what was said to the lawyer or to the police?
It was not. It was not. With respect to the first complaint witness, though, she discloses what she told to the police officers. There is kind of an extended period, well, in the context of this trial, is kind of an extended questioning of the first complaint witness about what she...
I mean, that's what first complaint witnesses do. They testify to what happened,
well,
what they were told.
The point of the first complaint witness is to testify about what they were told by the complainant, not what they in turn told to the police that the complainant
So I'm sorry,
had
I
told them.
misunderstood. So you're telling us the fresh complaint witness gave details of what the victim said to the police?
Yes, she did. In the transcript, 3 pages 29 to 30, the first complaint witness essentially was asked by the prosecutor, what did you tell the police? And she had reiterated that information. If I can find it quickly here in my... So on page 30, the prosecutor asked her about whether or not she had an opportunity to speak to the police officers independently in this case, and she said she thought so. And then the prosecutor goes on to ask her, do you remember giving a description of what the complainant had told you? And then she goes on. So essentially what she's doing is she's kind of repeating what she told the police, as opposed to just repeating what the complainant had told her. And
there was an immediate objection?
There was no objection to that.
There was none. No.
So that's one violation of the first complaint doctrine that we're arguing. Another is, a description of the responses. The first complaint witness basically said that she was in shock when she had learned about, this incident.
Wasn't that in conjunction with her inability to recall the details of what the victim had told her because of the years had passed and her emotional state upon hearing her friend's report of being raped?
Well, I think that's the Commonwealth's argument in this case, but I don't think that the first complaint witness herself described that as the reason that she had difficulty remembering. I think my recollection...
Exactly what she said, that I can't remember the details.
She said that she could not remember the details, but I don't think that she said she couldn't remember the details because she was in shock. And I think that's a significant difference. And the case law does talk about this giving information about your emotional reaction to learning about a complaint can be prejudicial because it does bolster the credibility of the complainant in the particular case. I would also suggest that the prosecutor's closing argument also kind of followed this common thread of bolstering the credibility of the complainant. During the closing argument, the prosecutor had discussed the complainant's demeanor on the stand. She said that she was emotional, that she was raw, that she was real. She mentioned that the complainant had a very difficult time identifying Mr. Bogard, that she had to look down when she was testifying. And then she kind of capped off this narrative by responding to the defense that, you know, why would somebody wait 4 years for trial and put themselves through this to make up a story? And I think that
But I mean, the prosecutor was really paraphrasing the defense argument.
She was, but again, it really kind of emphasized the fact that the complainant had to kind of go through the rigors of trial in order to testify, and that suggests to the jury that...
But importantly, the prosecutor does not say that. The prosecutor is making an argument based on the witness's demeanor, her demeanor on the stand, and why she should be found credible. And under the circumstances, a person would not have fabricated this, given what's occurred, in response to the defense of fabrication.
Right. Well, I think the argument that I was pushing was the statement that she makes after she discusses the demeanor. I think if you look at the two arguments in tandem, and that's what the court is supposed to do in these circumstances, look at the totality of the closing argument. She does go on to say that, you know, why would somebody wait for 4 years?
This isn't objected. There's no objection to this either, right?
There's no objection. No. So what I am arguing is that, you know, the cumulative effect of the lack of the limiting instruction, which put the jury in a poor position to compartmentalize the first complaint witness testimony from the remainder of the testimony, the closing argument statements, the testimony about the naming of other complaints, other persons that were complained to, and the emotional reaction to those complaints are all cumulatively prejudicial in the context of this particular trial. Again, this was a short trial. Most of the testimony or the evidence came in through the complainant's testimony. The case was not overwhelming. I think that the defense did a decent job making arguments in favor of reasonable doubt. There was evidence that the complainant had been drinking that evening. There was evidence that there was a prior relationship, that there were some text messages. The final text message did involve the complainant inquiring about Mr. Bogard's potential girlfriend. So again, when you look at the totality of the circumstances, I do think that all of these violations cumulatively prejudice Mr. Bogard, and reversal would be required. If there's no further questions,
Seeing none, thank you.
Thank you.
Ms. Hartley.
Good morning, and may it please the court. Brooke Hartley for the Commonwealth. This court should affirm the defendant's conviction, and I will take the issues in turn. I'm going to skip over the issue about the scope of the first complaint witness's testimony, except to point the court to the transcript on day 2, 162, which is where the victim does recount her verbal protest, and regrettably, that is also not in my brief, so I apologize to the court for that. And moving on to the other issues that the defendant takes with the first complaint witness testimony. So the first complaint witness properly testified to the events that took place, including her call to the lawyer and the fact that they went to the police station and gave a statement. The extent of the testimony regarding the lawyer was, we proceeded to call our friend, who's also a lawyer, to discuss what our options were and how she wanted to proceed. So there's no direct reference to a complaint here. Instead, it's a description of the actions that were taken after this first complaint witness heard from the victim. And I think this is if you look at the case law and the cases cited by my brother, the difference between this type of testimony and testimony that the court has taken issue with in the past is rather glaring. In Stuckich, the testimony at issue is that the victim told her mother and told Mike. So it's a direct reference to her making two other complaints. And the risk that we're worried about here is that the victim's credibility is enhanced because she told more people.
But wouldn't any jury infer that when she says, we talked to the lawyer about her options, that would include some repetition of her allegations?
I think the jury has to take one more step to make that inference, which is why I draw the distinction between a case like Stuckich.
Wouldn't any jury do that?
Possibly, it's possible, but I think the question here really is whether there was a substantial risk of miscarriage of justice from this question. And I don't think that the court could find that based on testimony that is really just a recollection of what happened, not a recollection of another detailed complaint, not even a direct reference to a complaint. And I would note in Stuckich that the court reversed, but not just on this issue. There was a plethora of other issues that the court said collectively amounted to a substantial risk of miscarriage of justice.
Can I ask you a standard of review issue? If the fresh complaint issues had been preserved after a vilus, we review for an abuse of the discretion, whether the judge abused his or her discretion in admitting it. And since they're not preserved, and that's the defendant's burden. Since it's not preserved, then we review for substantial risk, which is, again, the defendant's burden. But which is more difficult to establish? In other words, is substantial risk harder to establish than abuse of discretion?
I think a substantial risk would be more difficult to establish. I don't have any cases to support that, facts to compare, but
I honestly don't know the answer myself. But I was thinking about it, and when this comes up, whether was it an abuse of discretion for the judge to not sua sponte jump in and prevent some alleged or probable improper first complaint. Excuse me. I've been around too long, so I still say fresh sometimes.
Yeah, Your Honor, I guess I don't have anything to support my position that it's
Okay,
substantial risk is.
I don't want to detain you. Go ahead.
That's quite all right. I'll move on to the reference
Well, let me just ask you this before you move on. So why would it be relevant that the victim and the fresh complaint witness consulted with a lawyer and then went to the police? Why is that relevant at all?
I'm not sure that this is necessarily relevant evidence, but that doesn't mean that it's prejudicial, especially prejudicial to the point where it's a substantial risk of miscarriage of justice.
Okay.
Moving on to the reference to the police, which was we went over there to Hyde Park Police Station to give a statement. First, I think it's important that the description that my brother read to the court about what the first complaint witness testified to was her description to the police. Based on what she heard from the victim. I think it might be a little bit different if she was recounting the victim telling the police about what happened to her again. But regardless, what's most important here is that defense counsel put this before the jury, that the victim reported the incident to the police in her opening and again in closing, and put the investigative details before the jury, which I argue in my brief was a reasonable tactical decision based on the facts of this case, to argue that despite experienced detectives conducting an investigation, police chose not to charge the defendant. So the Commonwealth was entitled to reference that when the door had been opened by the defendant. Moving on to the defendant's argument that the first complaint witness testimony that she was shocked what was problematic. So the statement that she was shocked that the victim told her she had been raped was relevant, as Justice Meade said, to why she did not remember the details. But I think more importantly, this was not prejudicial. So typically, an emotional state is not relevant, but the real question is it prejudicial? And here, it's relevant because it explains why she didn't remember, but more importantly, if anything, this would support the defendant's theory of the case that they had this relationship, and how could he have done this? This was shocking to everyone involved, including the first complaint witness, who was the roommate who let him into the house. That was part of the defense argument at a trial, was that this person was familiar with him and let him into the victim's room, and they had this relationship, and this was a consensual sexual encounter.
She doesn't really say that the reason she doesn't remember is because she was in shock, does she?
No.
I'm looking at the transcript.
No, she doesn't say that. She said, so.
And that's an inference, I suppose, that one could draw from reading it, but
I think that's the Commonwealth's
she says
argument.
it's the passage of time. She says it's been a long
She says, I don't remember, and then I think in the next statement, she says, I was in shock, but she doesn't necessarily pair them together. I do think it's a reasonable inference, but I think the larger point here is that it's not prejudicial testimony, even regardless of its relevance. It's not prejudicial. It's really not the type of vouching that exceeds the scope of first complaint evidence. Turning to the defendant's argument that the judge's failure to give a contemporaneous limiting instruction created a substantial risk of miscarriage of justice. So this did not create a substantial risk of miscarriage of justice where the judge properly instructed the jury in his final charge. My brother relies on Cruz, and I don't think that case stands for the proposition that a contemporaneous instruction must always be given. It says that it is required and should be given contemporaneously, but it doesn't say that it must be given contemporaneously, especially where one was not requested, which is the case here. And I think if you look at the cases cited in the defendant's brief, that those are instructive to the court as to why this is different. In Lyons, the court concluded that the judge's failure to give such an instruction created a substantial risk, but there the Commonwealth had essentially introduced two first complaint witness testimonies. So you have the victim's 911 call and then a separate first complaint testimony. And similarly, in Marchant, which is an unpublished case by this court, the court reversed after two first complaint witnesses gave testimony, and there was no instruction whatsoever, no contemporaneous instruction or no instruction in the final charge. So this case is distinguishable. I would also just point the court to the timestamps. I make the argument in my brief that this occurred in close temporal proximity. It's not contemporaneous, it's not immediately after the testimony, but if you look at the timestamps, you can sort of gauge about how long it was. So the first complaint testimony finished a little bit before 10:26 a.m., and that's day 3, page 38. And then the instructions finished, so sometime before this, they finished at 11:48 a.m., which is day 388. So it's somewhere around an hour in between. So I would argue that that is close temporal proximity. I think it's also significant that in the judge's instruction, I know the defendant said he doesn't take issue with the instruction, and in the instruction, the judge specifically references the first complaint witness and uses her name, so there's no confusion as to who he's referring to or what he's talking about for the jury.
Did the instruction also mention the victim's first complaint testimony?
It did not mention that the victim's first complaint testimony. No, you mean the victim testimony that she reported the crime? No.
To AT, right?
I don't, Your Honor, I don't think so, but I don't know off the top of my head. I'd have to look to confirm that. Moving on to the detective's statement regarding the indictment. This was a proper explanation of the investigative process, and it also was relevant and had evidentiary value, again, where the defendant claimed in his opening statement that the Boston police interviewed the victim, yet made a decision based on that not to charge her. And I think it was necessary to explain the full picture to the jury, where otherwise they might be confused as to how this case proceeded when the defendant was not arrested by police. I will move on to the ineffective assistance issue, unless the court has further questions about that. So I argue in my brief that this is not the proper vehicle for an ineffective assistance claim, which I think is true, but at the same time I think you can glean from the record that this was a reasonable tactical decision based on the facts of the case here, where it was a he said, she said, and it was certainly not a manifestly unreasonable decision to argue that this was a consensual encounter, and to say that the police, after hearing from the victim, chose not to arrest her was certainly, by the defendant's argument, a testament to her credibility, that they argued was that she was not even credible to the police. Unless the court has further questions, I would rest on my brief for the remainder of the issues.
Seeing none, thank you.
Thank
Thank you
you.
both. We'll take it under advisement. Our next case is 24P142, Commonwealth versus Davis. Ms. Jacobson.
Good morning, and may it please the court. Haley Jacobson on behalf of Matthew Davis. I briefed several issues in this case, and I'd like to focus first on the motion to suppress, and then turn to the sufficiency of the evidence and the sentence enhancement trial with any remaining time. The analysis on the motion to suppress really boils down to two facts. The fact that Mr. Davis, when being pulled over, drove slowly before stopping at the next intersection, and the fact that he had a pending case involving a firearm.
What about the tinted windows? Doesn't that play a factor too?
So the windows were tinted, and the judge did find that, but the judge did not credit the officer's assertion that a car with tinted windows is more likely to contain a firearm.
Well, what about just common sense, just the fact that it raises a level of danger to the police, doesn't it?
So in terms of danger to the police, that might go towards the question of whether there's a risk to the officer's safety, but it does not go to the question of whether Mr. Davis was armed, which is required for a protective search. The police have to have reasonable suspicion that there was a weapon in the car. And the tinted windows don't go towards that issue at all. And I would also note that the car was not Mr. Davis's, which the officers knew, and so they could not have reasonably inferred that he was using the tinted windows to hide something, because it was not his car.
Didn't he say he didn't want to be seen?
He did say he didn't want to be seen, and that was on the video, although the judge did not make any findings about that statement. He didn't make any findings about whether that was suspicious, and it's really an ambiguous statement. In order to find that it suggests he was armed and dangerous would require speculation about what that even means, why he doesn't want to be seen. There's really nothing in the record, and the officers don't testify about why that would mean he would be armed and dangerous.
But it's a factor they can consider.
It's a fact that they can consider, except for the fact that it doesn't really suggest that it's armed and dangerous, and that's really the question before this court is whether...
we have to look at them all together in a constellation, not separately, right?
That's true, but facts need to support an inference that he is armed and dangerous even together.
There's a certain irony in the use of tinted windows to avoid detection, and yet they provide the justification for police intervention when they're excessive, don't you think?
So I'm not totally sure I understand the court's question, but in terms of using tinted windows to avoid detection, the judge did not make a finding that Mr. Davis was doing that.
It's a civil motor vehicle infraction.
Yes.
They have the police have a gauge that they can measure them.
Yes, they do. And of course, we're not challenging the fact that the officers had justification to stop the car.
I appreciate it. Go ahead.
I wanted to ask whether the unusual position of the seats in the video supports a reasonable inference of an attempt to hide some contraband.
So no, I don't think it does here for a couple of reasons. First, I would note that the seat position was really not a fact that was discussed at the suppression hearing. It came up at trial, but it was not a factor that the court really considered, or that the...
Well, it's in the video. That was an exhibit at the suppression hearing, and it was mentioned at the suppression hearing.
It is in the video. However...
So the officers may not have testified about that being a factor subjectively affecting their thinking about the situation, but it's objectively, it's quite unusual to see seats in that position, particularly a driver's seat, tilted back so far.
So I think the question of whether it is unusual to see for a driver to have the seat in that position is a question of fact that the motion judge did not make a finding about. And in addition, I think the Commonwealth's argument about the seat position at trial on the sufficiency of the evidence really relies on the location where the gun was found and the fanny pack, and that the seat position was there. However, at the motion to suppress hearing, or on the issue of suppression, the placement of the fanny pack, its existence even at all, cannot be relevant to the question of reasonable suspicion for the search, because the officers did not even know the fanny pack existed until they began searching.
Well, they looked in the back door. I mean, unless you're saying it's unlawful to open the back door of the car without reasonable suspicion, they looked in the right rear passenger door and they saw it. And it appeared to me that one of the officers saw it from the left side of the car as well, and that's why he went around and opened the back door.
The officers did see the fanny pack once they began the search, but reasonable suspicion must be established at the inception of the search. And both...
At what point does the search begin?
The search begins when, after the officer frisked Mr. Davis, he goes into the front seat of the car, and he testified at the suppression hearing that he saw the fanny pack just after he began searching the front driver's seat. And so he had not seen it before he began searching, and therefore the existence of the fanny pack, any information about it, can't be used to support reasonable suspicion to begin the search in the first place. Now, returning to the...
I did have one other question about the standard. Torres-Pagan talks about a pat frisk of the defendant's person requiring reasonable suspicion that he's armed and dangerous. Silvella, which comes slightly later, talks about pat frisk of a car and says it only requires reasonable fear that the defendant may possess a weapon or that there's a weapon in the vehicle. It doesn't incorporate that dangerousness element that was emphasized in Torres-Pagan. So what do we do with that? I mean, you cite Torres-Pagan, the Commonwealth cites Silvello.
So I also, in my brief, cite to the Supreme Court's decision in Michigan versus Long, which very clearly says that the officers must have a reasonable belief that the person is dangerous and could reach weapons like within their immediate surroundings.
That's for a pat frisk search of the car?
That is for a car. That is a car case, Michigan versus Long. So that's under the Fourth Amendment. But in addition, this court's cases and the SJC's cases, they use various language. But it all, at the end of the day, the standard really is whether the defendant, a reasonable suspicion or a reasonable belief that the defendant had a weapon and presented a risk of safety to the officer. So the presence of a weapon is necessary. A reasonable belief that the defendant had a weapon is necessary. Now, I think...
one advantage to the body cam footage is it kind of puts you in the position that the officers are in at the time. It's an extraordinary thing. And as I was watching the videos, I was thinking to myself, well, you know, you've got this slow roll going on, and you've got the window tint. It's at night. It seems like a pretty quiet street, although there is a little traffic going by. If I were the police officer, I'm thinking that in and of itself might justify an exit order, wouldn't it? Just to say, you know what, before I walk up to this car with the potential that the slow roll was because someone was reaching for a weapon or a weapon of some kind, not necessarily a firearm, but some kind of a weapon, to use on me, before I walk up to that door and expose myself as a target, I'm going to tell them, the occupants of the car, to step outside so I can deal with them and see exactly what they're doing. Why wouldn't that be reasonable?
So I have 2 points to make about that. First, the issue that we've raised here is not about the exit order, but about the search itself. So an exit order only requires a sense that the officer is, that his safety is at risk. However, a search requires more. It requires a reasonable belief that the defendant is armed and that presents a risk to the officer's safety. But I think maybe more importantly is that what happened here is that the officer did not ask Mr. Davis to leave the car when he walked up to the car. He waited, I think, almost 8 minutes before he asked Mr. Davis to leave the
Braver than I
car.
would be.
But I think it suggests that to a trained officer, as the SJC said in Daniel, or Commonwealth versus Daniel, I believe, that it suggests that to a trained officer, the risk to safety was not great because he did not ask Mr. Davis to leave the car and in fact left Mr. Davis and the passenger in the car while he walked to the back of the car, I believe twice, to speak with the other officer. So, yeah, so whether it would justify an exit order, it doesn't justify a reasonable, or it doesn't justify a search of the car because the fact of that Mr. Davis drove slowly for a block or before to the next intersection before stopping is not enough to suggest that he was hiding something. It's certainly less suggestive of concealment than...
What about his history of gun cases, including an open case?
So there was a pending case, and the officers did testify that they knew about that. So the judge...
Was there more than a pending case?
The only other evidence before the judge about Mr. Davis's criminal history was the officer's testimony that he had a prior history with drugs and firearms. There was no other detail besides that. Not how many cases, not how old they were, not dispositions.
That's evidence that the judge can credit, right?
The judge can credit the evidence, but reasonable suspicion must be based on specific articulable facts.
These were articulated.
Well,
He has a history of gun cases, and an open one, meaning he's still in trouble with guns.
the open case, I think, is a specific articulable fact, but the prior history is a vague statement because it doesn't provide...
But the open case, assault with intent to murder, assault with a dangerous weapon, and threatening, from a week before, or at least there was it's a little unclear, but at least there was a hearing a week or 10 days before, and it's appeared that the incident had been the previous day. So it's a pretty recent charge regarding threatening or to murder someone with a firearm, it appears.
So just to clarify, I believe that the hearing in the pending case was on December 7th, and this stop was on December 21st, so it was a couple of weeks.
Okay.
But either way, I think even with a pending case and the fact that Mr. Davis drove slowly before stopping at the next intersection, that is not enough to establish reasonable suspicion.
And he's changed in demeanor from a prior stop by this same officer.
So I think that the change in demeanor, as I've definitely...
I thought you were going to start there.
Well, it was not a main factor for the judge, and I think it's evident that that does not support reasonable suspicion. The fact that Mr. Davis was polite...
The fact that he was extremely rude last time, and now he's Mr. Nice Guy, one could draw an inference that he was trying to end this stop as quickly as possible by being polite as possible because he's concealing a gun.
I think that that's speculation on the part of the officers, and in addition, the fact that someone is nice and polite simply cannot support a suspicion that they are a risk to the officer's safety.
Not by itself, no, but again, as I said before, we have to look at all of the things together.
But even the fact that someone is in a bad mood one day, in a good mood another, that they act differently on 2 different days is not enough to support reasonable suspicion. And here, this case is quite different than the case the Commonwealth cites, Sweeting-Bailey, where the officers in that case relied on the fact that the passenger there was aggressive, uncooperative, and angry, and that they knew that this was particularly uncharacteristic behavior for him because they had known him for years, I think one of the officers, and had interacted with him many times.
This is just the reverse of that.
It's not a reverse of that because in this case, the officers had only met Mr. Davis a single time. They didn't have a basis to say whether his behavior at this stop was characteristic or not.
They could compare it to his behavior at the other stop.
They could compare it, but the comparison just doesn't provide much insight here because it's totally plausible based on...
It does provide insight that he's behaving differently now than he had before.
Well, he's behaved differently on one day, and I think the fact that someone behaves differently from one day to another just doesn't provide a lot of insight. It certainly doesn't give the officers a basis to believe that his behavior is particularly uncharacteristic. They don't know what is characteristic for Mr. Davis because they've only met him a single time. And just returning to the kind of overall question of reasonable suspicion, I think it's evident that the facts that this court can rely on and that the motion judge relied on were the pending charge involving a firearm and the fact that Mr. Davis drove slowly before stopping at the next intersection. And it's evident that those two facts do not amount to reasonable suspicion when you compare this case to this court's recent decision in Commonwealth versus Johnson-Rivera, where this court found that there was reasonable suspicion that the defendant was armed and dangerous. And there, this court called Johnson-Rivera a close case, and yet there was much more there than there is here. So like here in Johnson-Rivera, the defendant had a pending charge involving a firearm. Like here, the officers believed that the defendant there was trying to hide something, but what the officer actually saw was much more indicative of concealment. He saw the defendant trying to hide a bag behind his body. But that was not all that was present in Johnson-Rivera.
I thought the officers testified here that the slow roll was considered to be a tactic to hide something in the car. Maybe a gun and a fanny pack behind the reaching point where the seats reclined.
They did testify that they believed that that was true, but they said their testimony was that, based on my experience, I know this to be true. But there was no details about the experience that they were relying on. And in Johnson-Rivera, this court reiterated the fact that in order to rely on their training and experience, an officer has to provide details, provide specifics about that training that they are relying on and how it correlates to the observations made. And here there were no specifics provided. So that training and experience does not support the officer's reliance here. And again, in Johnson-Rivera, there was more than the facts that we have here. There was the fact that the defendant was particularly nervous, the officer's knowledge about fanny packs, which he could use, unlike here because the officer did not know about the fanny pack prior to the search. There was also several other factors that the court cited, and yet it still called Johnson-Rivera a close case. So if Johnson-Rivera is close, then it's clear that this case falls below the line when the only proper factors were the pending charge involving a firearm and the fact that Mr. Davis drove slowly before stopping.
Okay, thank you.
If there's no other questions, I'd ask the court to reverse. Thank you.
Mr. Steinfeld.
Thank you very much. Good morning. May it please the court, Kenneth Steinfeld for the Commonwealth. I'd like to start with the slow roll, which I think is essential to both the analysis for the reasonable suspicion and for the sufficiency of the evidence at trial. That's
I
what
just
really
ask that at some point you get to the issue of the Creighton and Due in-court ID at the penalty, at the enhancement trial.
Oh, I certainly would. That's
Okay.
That's certainly a part of my argument. I actually was considering starting with that, but I thought I would go in order. The slow roll of the vehicle, in fact, Officer Piccirillo had testified that on a previous occasion, he had been involved in an incident where a vehicle had slow rolled and there was a firearm found in the vehicle. So this is not just an abstract, well, I think it might be connected. The officer testified as to his specific experience where he had been there when it had happened. It is also reasonable that an officer at that time of night who sees that kind of behavior might believe, as I believe Justice Meade has said, that it was time or that the driver of the vehicle or someone in the car had taken that time to secrete a firearm, which he had on his person. There are no mass cases on slow rolls. I cited a case from the 10th Circuit, which I think is directly on point, that it is reasonable for an officer to think that that's what happened during that time.
Does it matter if it was on his person?
No, it's got to be in the car because we got to show that there's a firearm in the car that might be a danger. So it doesn't matter.
But does it matter if it was on his person before, in your theory, he put the fanny pack behind the passenger seat?
No.
It could have been sitting on the top of the console or in
exactly,
the
like
side
on the rear
pocket.
seat, just to make it less visible from where it was to when they stopped. Doesn't matter if it was around his waist, but it makes sense that it was around his waist given the seat being fully down, which I would argue nobody would drive that way. So it's fairly clear, or it's a fairly reasonable inference that the driver, as soon as he saw the lights come on, he pulled his seat back all the way so that he could take it off and put it. He may also just have put the seat back so that he could reach into the back seat and put it onto the floor. We don't know, but it doesn't matter, because the slow roll is very, very important in this case. And I think that it strongly suggests that the officers, when they approached the car, had a reasonable suspicion that something might have been secreted during that time.
Do you think they needed reasonable suspicion that he was dangerous?
No.
That's the Silvello-Torres Pagan question I asked before. I mean, to pat frisk him out of the car, they needed reasonable suspicion that he was armed and dangerous. And the pat frisk of the car comes after that.
Right, as I cited
You
my
can't
brief-
pat frisk the car till they get him out of there.
Right, the standard, I think, is set forth very, very plainly in Silvello, which I cite at length.
Right, but how do you reconcile that with Torres Pagan, which was decided like a few weeks earlier or a month earlier? I'm not sure.
Well,
Very close in time.
if it's earlier, then obviously the subsequent case governs. To the extent that there's any inconsistency, then you would say that the later case implicitly not repealed, but it revised, or it narrowed down, or it clarified what the standard was. But I think it's safe to say that it's okay if a reasonably prudent person in the officer's position would be justifiably fear for his safety based on specific and articulable facts. That's enough. And then, of course, the next paragraph, it says that a warrantless search of a vehicle is justified when an officer reasonably feared that the defendant may possess a weapon or that there is a weapon in the vehicle. That's in Silvello, and I think that's the appropriate standard that should be applied here. And, of course, the test is not a subjective one. It does not matter whether the officers actually feared for their safety, and there was a period of time before the exit order, but that doesn't matter because there was more than sufficient evidence to support a finding that a reasonable officer in their position would have found that that standard was met, that there might be a firearm secreted in the vehicle. Now, the tinted windows, I think, is also very important. There was specific testimony from Officer Piccarello that in 90% or more of the cases in which he had seized a firearm from a vehicle, that vehicle had tinted windows. So there's definitely a correlation.
What we don't know is how many vehicles with tinted windows don't have firearms in them. And unless we know that, what use is the tinted window factor?
Well, I think that shows that there's a correlation between the two.
Well, we don't know the strength of the correlation unless we know how many cars with tinted windows don't have firearms in them.
But it's a factor that goes into it, and it's certainly enough for a Boston police officer to have his suspicions on higher alert because the windows are tinted based on his specific experience with there being firearms in cars with tinted windows. Now, as to Justice Meade's point earlier about there being an irony on the tinted windows and not being seen, and that's the reason to pull someone over, I think that's partially explicable by the fact that from what the defendant said, he seems he didn't want to be seen out there by anyone, not just police, but by other people on the street. So it's not just so that he's not seen by the police.
Looking at his demeanor on the video, the body-worn camera video, do you think that's a reasonable interpretation?
I'm sorry, I didn't hear the start of that question.
Looking at the defendant's demeanor when he says that on the video, do you think that's a reasonable interpretation? That he's saying, oh, I have the tint turned way up, officer, because I don't want to be seen out here. Like he's trying to hide something? Is that how you interpret what he said? Or is that a reasonable interpretation?
I think that an officer could reasonably think that I don't want the police to know that I'm in this car, as well as other people on the street. I'm not sure if that answers Your Honor's question. I'm not sure that I fully understand the gravamen of the question.
So you're saying he meant he doesn't want people to know that he's in the car, not necessarily that he's trying to hide something that is in the car.
Yes. As to that comment, I'm just going to the point that it's not totally ironic that people who don't want to be seen on the street have tint on their car. It's a separate point that there's a correlation of some degree between having that tint on the car and the possession of a firearm. Now, the recency of his firearms case, I think is very, very important. It's about 2 weeks earlier. He's been arrested and charged in a case out of Norwood, I think it was in the Dedham District Court, that involved violence and possession of a firearm within 2 weeks, and the officers know about this. And they also know that the car that was found in that incident was just found around the block fairly recently, so they're on alert as to that incident. And I think that if you factor in all of those factors, obviously you've got to take them all together. None is specifically, none is solely responsible or enough.
Ms. Jacobson tells us he's presumed innocent of that charge because he hasn't been convicted yet.
Sure, but an officer, this has to do with how a reasonable person would take information and process it, and would it justify a reasonable fear. The fact that somebody was recently charged with a firearms arrest, I think that an officer has to be able to take that into account, though there's been no conviction. He doesn't have to be able to show beyond a reasonable doubt or by a clear and convincing evidence that there's going to be a gun in the car. That's not the standard here. So I don't think that it matters at all that he is presumed innocent. It's the recency of it. And as Justice Meade has pointed out, the officer also testified that he had a history of firearms and drug offenses. I think if you take that all into account, that's more than enough for reasonable suspicion. Also, I think that the demeanor difference is important. The judge did not place a lot of weight on it, and nor do I. But it's not, of course, that he's being polite. Sweeting-Bailey says if it's uncharacteristic, that does not mean that the defendant has to have known that that the officer has to have known the defendant for years, but merely that he has a prior experience of him. And during that prior
know what the defendant's character is.
I'm sorry, Your Honor?
He has to know what the defendant or the suspect's usual character is to decide whether behavior is uncharacteristic, doesn't he?
Well, I don't think he has to know what his usual behavior is. He has
And
to know
how can
what
you
it
tell
was
if
on
something's...
that.
Sorry, go ahead.
He has to know what it was. And I agree that it would be a stronger argument if he had a lot of interactions with the defendant in the past. But I think this one was very, very recent. It was only 15 days earlier. And his demeanor and his behavior were very, very different. And it may have been attributable to intoxication by the defendant, but it may not have been. The officer certainly didn't have to give him the benefit of the doubt and say, oh, he must be being nice to me now because he was drunk then and he's not. Now, he certainly could say, as has been pointed out, he's being nice to me because he knows he has a gun in the car, so we're just having a casual, very friendly conversation. Actually, it's kind of funny, a few of the things that they say to each other during this conversation. It was extraordinarily different from the combative, vile, vulgar things that he said to the officer during the first encounter. There's a world of difference between them, and the judge so found, and that was supported by the record.
Why don't you get to the ID?
Oh, from the
sentence
Second trial.
Subsequent offense trial? Well, I see the strength of the defendant's arguments on both points, although I don't concede anything. I think that it went to the weight of the evidence, not its admissibility. I also point out before, if the admission of both the ID and the date evidence, the date of birth evidence, was wrongly excluded, it was not prejudicial error. I discovered just last night some evidence in the record that also was before the judge, and I would point the court to pages 130 and 133 of the appendix. 133 is the last page of the federal judgment of conviction. It has his name on it. That's the prior conviction. 133 is the RMV data sheet. And if you look at the federal conviction on RA 130, it says date of birth 1988, and it has the last 4 digits of the defendant's social security number. That's on the federal conviction. Also has the name. And then if you look at the RMV data sheet, it has his whole social security number, including the identical 4 digits that are on the federal conviction. It also has a photograph of the defendant, and the judge can see him in court. So that's how you tie this Matthew London to the Matthew London Matthew Davis, his middle name is London. That's how you tie, that shows beyond a reasonable doubt. So even if the judge should not have allowed the in-court ID or testimony as to his birthday, they would still, it's not prejudicial because the record had this other evidence.
So,
The judge in his finding, I'm sorry.
so the question I had was about the point from Dew, that good reason consists of circumstances where an in-court ID is not material to a determination of guilt or innocence and serves merely to inform the jury that the person sitting there is the person whose conduct at issue. So what does that mean, not material to a determination of guilt or innocence? And why wasn't the ID here very material to the determination of guilt or innocence?
Well, it's not guilt or innocence. It is guilt or innocence as to the identification of this person being the same person who had previously been convicted of a serious drug offense. So I think there's a merger, because a subsequent offense trial is not a classic, did you do a crime, did you do an act? It is, are you the same person who was previously convicted? So I think it's a different analysis. I don't think that applies directly. And as I say, I think that there was enough evidence in the record to show that the judge in his finding, and as to the date of birth, the officer testified that his memory had been refreshed by the police report.
Right. Can you come back to the determination, not material to determination of guilt or innocence? I understand your point.
Yeah, no,
about the birth date. But isn't this material to a determination of whether this defendant had previously been convicted of a serious drug offense?
Yes, it is material. I mean, I can't say that it's not.
Well, the defendant's identity is material in every case, isn't it?
Yes, it is in every case. But here, it's the sole purpose of the trial is to determine whether the identity of this person is the same, as I said, as the identity. And the judge in his finding relied not on the exact date of birth as the officer testified. It may stretch credulity that somebody who'd arrested a man in 2008 would know in 2023 what his exact birthday was. But he did know the year. And the judge in his finding said the year of birth was the same. So that's what he based his finding on, rather than the full day and year. I also made a mistake in my brief on page 38. I said twice that his date of birth was 2018, and it should have been 1988. So I apologize for that. I made the same error twice.
We'd be in juvenile court.
Pardon me?
We'd be in juvenile court.
Right. Well, we are not there, but that's certainly true. He'd be very young then to be driving. Lastly, I'd like to say that I do agree with
You have to say it quickly, Mr. Simon. Your time's up.
Yes, I'm sorry. Oh, pardon me?
Your time is up.
Oh, I'm sorry. I missed that. That went by very quickly.
It's that pesky red light blinking.
Thank you very much.
Thank you both. Our next case is 23P 849, Commonwealth versus Graham. Mr. Murphy.
Good morning, Your Honors. Owen Murphy for for Mr. Graham. Excuse me. So, at trial, the Commonwealth's theory was that Mr. Graham warned Ms. Mattson, and his warning preceded the assault and batteries. So I think realizing that that theory of the case was based on an insufficient evidence to prove witness intimidation, it offers a new theory in its brief that actually the warning was subsequent to all those assault and batteries. So I think...
Isn't it, can we call it something other than a warning when he threatens to kill her and have his boys kill her?
I didn't want to use the word
pretty much a threat.
I didn't want to use the word threat because that was a charge too, so I phrased it that way, trying to just create it, use it consistently so the court would know what I was referring to. Yeah, I think maybe it could have supported a threat charge, but not the witness intimidation charge.
I'm just, characterize it any way you want. I didn't want it to affect your credibility.
Oh, no, I definitely understand the court's point. And I didn't mean to mislead the court. I think.
No, yeah, I wasn't misled.
Okay. Yeah, I think I pretty clearly stated that, what he actually said was that he threatened to have his boys
So
killed.
the question is, when did the threat occur?
That is the question, and we really don't know based on Ms. Matson's testimony. And I think the prosecutor, in her closing argument, candidly, to her credit, admits that we don't know when it was, because in her words, Ms. Matson didn't know. And so I think that's the problem.
Isn't it a reasonable inference that the defendant wouldn't make a threat to kill the victim over telling someone else about the phone or his interest in her daughter or Nikki, or that he wouldn't threaten to kill her over not revealing those things, that he would threaten to kill her because she had something on him that was a crime?
Yeah, so I think if we're going to say that we can make that inference, then we're saying that the warning or the threat came after the assault and batteries, then we're opening up a new problem, because then we're increasing the risk that there was a non-unanimous verdict, because now there's 3 discrete incidents that the jury could have selected from to qualify as a prior possible crime.
Well, didn't this assault occur over several hours?
Yeah, I would say there's the October 14th event, which was a prior possible crime. There was,
He was acquitted of that.
I'm sorry,
Wasn't he acquitted of that?
yes, but it still could have qualified as a prior possible crime.
Except they acquitted of him of that.
He was, yeah, if you look
So
at,
there was no confusion there.
yeah, the instructions on the definition of a prior possible crime, and this is what the judge stated to the jury, is that it doesn't actually have to be proven beyond a reasonable doubt. It just has to be something that could have led to a possible investigation. And he was investigated for that. He was charged with that. So certainly I would say that that could have qualified as a prior possible crime that would lead to an investigation, because that's exactly what happened. And then you also have what I would call the October 20th incident, which is when he took her phone and left. I don't think that's sufficient to prove a prior possible crime, but it's certainly something that the jury might have considered in determining if there was a.
Didn't his attack begin on the evening of the 20th and go into the early morning of the 21st?
Yes, but it was disrupted by time and place, so I think that's its own discrete event based on the unanimous verdict jurisprudence. So
I mean, the prosecutors expressly argued that the witness intimidation charge related to those events between 20 and 21.
Well, I don't know that I would say that it was like a clear express argument. She says that, and if we're going to just focus on the prosecutor's argument, then the evidence was insufficient again. So that's kind of what we run up against. It's like, are we going to say that the prosecutor actually did direct them to find witness intimidation based solely on the events of October 21st? Because if we're going to say that, then she proposed a theory of insufficient evidence.
But isn't it the province of the jury to take this evidence and decide, based in the context of the statements that were made by the defendant, whether it constitutes a threat that would be sufficient for intimidation?
Yeah, but we don't have, it's important to consider that this is a charge that requires them to prove specifically the element that there was a prior possible crime that supported the witness intimidation. So they have to give us, something.
But what do you mean a prior possible crime?
That's, well, one of the elements of intimidation is that there was a prior possible crime before the act that constituted intimidation. So,
Says that in the statute?
in the case law, yeah, Fragata.
Doesn't the case law say that it's the context that controls? So in other words, that if there's a conversation that's going on all night long, that the jury can consider the overall context of that dispute that involves physical violence in deciding whether or not there was an effort to intimidate this witness?
So I think that the answer to that question is emphatically no, because when you look at Fragata, it's very similar to this case. There was a elongated dispute there that involves several discrete acts of assault and battery and intimidation and name-calling at least, and the court's decision was that, the Commonwealth's theory in that case was that the act of intimidation occurred at the point that Mr. Fragata took the victim's phone, but the evidence was insufficient, the court found, to prove that theory of the case, given that prior to him taking the phone, there was no evidence that there was a prior possible crime. So there has to be something that actually precedes the act of intimidation, which is the subject of the intimidation, what he's intimidating her from pursuing, which is a complaint to the police or testifying or something like that. Just an act of intimidation in and of itself is insufficient. I think Fragata emphatically says no to the question that you just asked.
Well, there was more than just abusive language in this case, like there was in Fragata, right?
Well, if we want to look at, if we consider October 14th and October 20th, then possibly, but then if we're going to do that, we run up.
Which is the evidence in this case.
It's the evidence in this case, but it's not the prosecutor's theory of the case. So Fragata also states that, you can't, the prosecutor can't propose one theory of the crime and why it constituted witness intimidation, and then.
When we're looking at sufficiency, it doesn't matter what the Commonwealth's theory is. We look at the evidence in the light most favorable to the Commonwealth.
Well, I disagree with that, and I direct the court's
Well,
attention
disagree with, tell the SJC, because that's what the law says.
So that, going into this case, was my understanding of it as well. But if you look at Fragata, I mean, it tackles the very question that we're talking about now. It's the Commonwealth there proposed the theory of witness intimidation that I just described, and the court said, no, the Commonwealth's theory is incorrect. It's insufficient to prove intimidation based on what they're proposing. However, the court could, the prosecutor could have argued that the several other facts that supported witness intimidation and the evidence would have been sufficient. And that's actually highlighted by the Commonwealth too in its brief in a footnote. So the conclusion there was that
Maybe if there's some temporal distinction, but you have an acquittal on the 14th, right? So that wasn't it.
So I don't think there was a temporal distinction in Fragata, because like I said, that was one elongated event.
There's one here. Or had there, if the Commonwealth's alleging the crime only occurred on one date and all the evidence says it occurred on another date, then your argument would have some force, but that did not occur here.
Well, I think it did, because they proposed three different things that could have been the predicate for witness intimidation. And if we're just going to rely on their theory of the case that it all happened on October 21st, then again, they introduced insufficient evidence.
You're saying with respect to the 14th that just because they acquitted him of that doesn't mean that it wasn't a potential charge that he could have been trying to intimidate her not to report?
Yeah, I mean, it has to be, because he was charged with that and investigated for that. So it definitely was a prior possible crime that could have led to an investigation. October 20th, I don't think was a prior possible crime, and the Commonwealth actually concedes that in a footnote in its brief. And if you look, I think it's volume 1, page 178 of the transcript. There's very little detail, if any, about how the phone grab occurred. It's just one line, he took my phone and left. So, I mean, there's no evidence that that's a larceny, that he, was violent when he took the phone, nothing like that. So that's insufficient to constitute a prior possible crime.
Can I ask you about your last argument where you say the complaint does not allege, or the statute doesn't provide a penalty for what was alleged here?
Yes, you can, Your Honor. Can I just point out one thing briefly? If you look at the verdict slips, the one for intimidation, all the other verdict slips have a date on them. The one for intimidation doesn't. It really gives no direction for them to resolve the prior possible crime element. And in fact, when you view it in comparison to the other ones, it misleads them to think that they could consider the various dates. I just wanted to get that in. But yeah, in regard to argument 4.
So you're essentially saying that this complaint is defective as a matter of law?
I'm saying that the statute fails to set forth a penalty, yeah. That's the way I would word it.
But as alleged in the complaint?
As alleged in the complaint, and just that the statute is deficient. It fails to state a crime.
So aren't you obligated to bring that in a motion to dismiss prior to trial?
I think it's actually a jurisdictional issue because he was convicted under a statute that fails to state a crime. So there really is no statute that supports this conviction.
Well, if it doesn't have that doesn't make it jurisdictional by itself, though, right?
I would disagree with that. It's my understanding that, if there's a statute that actually fails to state a crime, it can't be enforced. The fact that it wasn't objected to.
So, I mean, that's where I go to and 277-47A says you have to bring that in a pretrial motion to dismiss or it's waived.
That could be the case, Your Honor, but again, I think that it goes to whether or not the trial court had any jurisdiction to even prosecute him or enforce that statute where it fails to state a penalty and therefore isn't a valid criminal statute.
I'm still hung up on your point about the no date on the verdict slip on the intimidation, because the indictment itself specifies that it was on the 21st. So isn't that the end of the matter?
I don't think that the jury got a copy of the indictment. I think they got a copy of the verdict slip.
Well, at a minimum, they read the indictment, so.
Yeah, I mean, they read the indictment briefly during the course of, a long colloquy. I don't
That's
think
what's
it's-
alleged.
The verdict slips have dates for the two A and B domestics.
Right.
But they don't have dates for the other charges, assault and battery, punch in the face, kidnapping, or intimidation of a witness. So intimidation of a witness is not the only charge as to which there's no date on the verdict slip.
Fair enough.
There was just a need to distinguish because the only charge with respect to the 14th was the A and B.
Yeah, so I actually kind of realized that difference moments before I stepped up to argue, so I wanted to point it out to the court. I think it's still important because, this is a case where there were three different timeframes.
But the intimidation doesn't occur when the witnessing of the crime or alleged crime occurs. It occurs at the time of the attempts to interfere. So if he witnessed a crime, or if she witnessed a crime on the 14th, and the only thing that had happened on the 20th was he said, if you tell about what happened last week, I'm going to kill you, that doesn't mean that intimidation occurred on the 14th. It occurs on the 20th, doesn't it?
Exactly, yeah. But
so the verdict slip doesn't have to specify, or the jury doesn't have to find the date on which the witnessing of the alleged crime occurred.
No, I disagree because I think it has to agree on every element unanimously beyond a reasonable doubt. So when we have three different discrete incidences separated by time and place like we do here, it doesn't have to be on a verdict slip necessarily, but they need some type of instruction on what facts actually support that element, which they didn't get here. They got very little, if anything, about that.
None of that argument's preserved, right?
I'm sorry?
None of that argument is preserved.
Right, that's correct. Yeah, but when you look at the non-unanimous verdict law, yeah, there is definitely a substantial risk here, given that they had absolutely no direction. The judge didn't clarify it through his instruction. In fact, he probably exasperated it a little bit when the jury asked about the non-unanimous verdict, and he gave them a broad definition of what it could be, which I think was accurate, but it opened the door to them considering the 14th, and it opened the door for them considering the 20th, the phone grab. And if we're going to just make believe that the evidence said that the threat or warning came after the assault and batteries, then it opened the door to that too. But certainly there was no basis for the jury to infer that. They needed some type of context, and they had nothing. I mean, if Ms. Matson had testified that he threatened me that if I told about the assault and batteries, it'd be a lot different. If she had testified that, the last thing before he stormed out the door was threatening me not to report the assault and batteries, then I wouldn't be up here making this argument. But she
All right,
gave
we're going to
them
have to hold you there,
absolutely no
Mr.
context.
Murphy. Your time is up.
Thank you.
Ms. Jansen.
Good morning. May it please the court, Catherine Jansen on behalf of the Commonwealth. I think I'll first start with the specific unanimity issue. I have to say, conceitedly, I was a little unclear about what really the case law requires in this context, because I'm not sure that with this witness intimidation charge about what the potential criminal violations are, if that's more akin to the Santos line of cases where a jury doesn't need to agree on every detail regarding how the crime was committed, or if, this, because here, unlike Palermo or other cases where we see this where it's usually a bunch of discrete and decent A and Bs on diverse dates, those are all acts and crimes that are completed, and each of which on their own could be their own criminal crime committed. Whereas here, the only alleged act of witness intimidation was the threat to kill her on this date. So I'm unclear really on what the case law would require in this type of circumstance of this almost sub-element of what could be the potential, she could be a potential witness to, but I think the court doesn't necessarily need to address that because here it's not preserved. The question is whether there would be a substantial risk of miscarriage of justice that they wouldn't be unanimous on the conduct of the defendant and the potential criminal violation the witness that she was a potential witness to. And I think here it was clear from the prosecutor's closing argument that it was these assault and batteries over this protracted 8 or 9 hour period where he kept her from leaving the room. She had bruising and a chipped tooth and swelling face that he did not want her to report that long assault.
So what case says that the prosecutor's closing argument can narrow down the potential predicate?
I understand what you're saying. I would point the court to Zane Z, 51 Mass App Court 135 at 139, and I would say there it suggests in that case that there would be no substantial risk if a prosecutor had communicated the theory as to what act or incident was the crime for which what went to what. The crime charged. That didn't happen in that case, so it's a contrast case, but it lends support to that. And I would also point to Palermo as a contrast case on that, because there the SJC specifically noted that the Commonwealth had argued that either of those threats in that case could have been one of the charged crimes. And so I think if you look at the inverse of that, it's reasonable that if there's direction and we're trying to avoid jury confusion about what is the act that is the charged crime and what they're convicting of, that's the risk. And so you're looking at whether there's a risk that the jury's verdict would have been different if they had been so instructed, and I don't think there's that risk here.
Did the Commonwealth proceed on alternative theories of guilt?
No, my understanding here from how the prosecutor argued the case and how it was presented is the theory of guilt was that she was a potential witness in the potential criminal violation that was linked to this threat was the assault and batteries. So I don't really think it's alternate theories.
No,
but
and you cite that nice case, Commonwealth versus Arias from 2010 in there.
Yes, I know Your Honor authored that case. So here, I just don't think there is a substantial risk that the jury was convicting potentially on October 14th conduct, or, and again, I would even suggest that, well, I think that taking the phone and abusive language on its own, the taking of the phone, which wouldn't have been enough for witness intimidation, that's all part of this, this incident, this protracted incident. And here it was clear from the prosecutor's closing, she was referencing the punches to the face and this ongoing protracted argument and incident that, that it was what the threat was linked to. Dovetailing into the sufficiency argument, I would just say that we're looking at this in the light most favorable to the Commonwealth. Victims, sometimes they are not as clear as we would maybe like them to be when they're on the stand, but however, I think based on the entire context of the incident and her testimony, it's a reasonable inference for the jury to find that this threat came part and parcel with this abusive, assaultive conduct. She did say he didn't get violent towards the end of the incident, and when I say violent, it could be the punch to the face that chipped her tooth, but there was also evidence he was not letting her out of the room. He was grabbing her, and she had bruises from that entire protracted incident. So I think, and also just based on the context of this incident and the fact that there was substantial evidence of the assaults, that it's fair for the jury to infer that he would make this threat based on not wanting her to report this to police because there was substantial corroborative evidence. I would be happy to address any of the other issues in the brief if the court would like. Otherwise, I'd be happy to rest on my brief.
Anything, Peter? No, seeing that, thank you.
Thank you very
both.
much.
We're going to take a short recess.
All right, please. All right, please. This court is now in session. Please be seated.
Our next case is 23P564 Buchanan versus the City of Greenfield and others. Before we start, as you're all well aware, there is a sealed matter in this case. So if you do your very best to omit names or other descriptive characterizations that would indicate who's who, because we've all read the sealed transcript, so we are fully aware of what occurred. And if the panel requires more information after argument, then we'll make a proper inquiry and notify other. Mr. Keston.
May I address, may I argue it at all without name?
I cannot hear you.
I apologize, I do not have COVID, I do not have a fever.
Yeah.
As of this morning, I did not have COVID, I do not have a fever, but I'm not as loud as usual. So Your Honor, am I allowed to argue something about it?
Oh, you're allowed to, by all means.
Okay.
Okay.
All right, Your Honor, may it please the court, my name is Leonard Keston, and I'm counsel, well, right now just Chief Hague, but I'm arguing on behalf of the city and Chief Hague. This is a very important case. It's important to all the parties. It's not a run-of-the-mill case. It's an important case, and everybody in this case deserved a fair trial. And we did not get one. All the parties are here. They traveled from Greenfield to be here today. The presiding judge the word we used was unhinged throughout the case, but the ruling about the Confederate flag is what this appeal is about. The behavior.
Can I ask, is there any exhibit or in the appendix, was a photograph entered of the flag?
No, just testimony.
Just testimony, okay, all right.
Here's the issue.
Go ahead.
Okay? The plaintiff, Officer Buchanan, was not promoted and was disciplined, and he sued claiming he was being treated differently than other officers, and it was because of his race. He had a co-plaintiff, who was then Lieutenant Dodge, and Dodge sued claiming he was a whistleblower. That was the case. The salient event that Officer Buchanan and his lawyers wanted to compare everything to was where he did a stop. Officer Buchanan stopped a group of young men, with the young man driving around Christmas time, and he told the young man, I'm going to give you a break. I want you to spend, I forget, $135 on a gift for your mother, and bring me the receipt, because I know where you live. The concern by the department was not giving the young man a break. It was the order, which was clearly illegal and violated the young man's civil rights, to come back. So Sergeant McCarthy was informed by another officer about this situation. He wrote a memo, that was it, saying this is what happened. I don't think it's a big deal myself. When the chief got it, Chief Hague got it, they did a full investigation of it. The chief and the then mayor wanted to terminate Buchanan for this. The chief, that's the testimony. The chief said, no, we shouldn't terminate him. He ended up with a 3-day suspension. He arbitrated it, and the arbitrator found that he shouldn't have been suspended, but he was also demoted. That was that. The flag had nothing to do with any of this. At around this time, Sergeant McCarthy, who didn't even testify, didn't even call him, Sergeant McCarthy owned a piece of land, a vacant lot with a garage on it. They intended to build a house. A neighbor complained at one point, saying that when the door was open, he could see there was a Confederate flag on the back wall, inside a private garage. And Officer Buchanan and his legal team wanted to introduce that to say that the chief should have disciplined him for that, but didn't while he disciplined Buchanan. From the outset of the case, started on March 22nd, when I first filed these motions, I said the chief couldn't discipline him. The chief could discipline him if you repealed the First Amendment. The law's clear on it.
You know, let me just ask you this, because I'm very sympathetic to your argument, and you made a very good argument in the brief, and I followed it, and
Yes, sir.
and you've kind of won me over on that. It seems that the whole flag evidence was not relevant, and to the extent it may have been somewhat relevant, it was certainly prejudicial, unfairly prejudicial. But the question is, the judge, apparently, you won him over too at a point in the trial, a little late in the trial, and he then changed course and instructed the jurors not to consider the evidence. So we have that, plus there was substantial evidence, other evidence unrelated to the flag, that jurors could readily conclude that this officer was treated very unfairly, very differentially, based upon his race. So what do we do with that?
What you do with that is you evaluate all of it. Because this is a situation, there can be nothing, I can think of almost nothing more inflammatory than throwing in front of a jury in a race case, than forcing me to cross-examine Officer Buchanan defending that flag. I begged the judge over and over, don't make me do this. Don't make me get up for the jury and suggest that it's okay to have a Confederate flag. But he did it. And when did he reverse himself? Right before the closings. And one thing that Mr. Ryan and I agreed on is it's too late, Judge. The plaintiff's counsel also said it's too late. You can't do it now.
But the instruction told the jury, as Justice Hodgens said, to disregard it. And we have to presume that juries followed judge's instructions. And there'd have to be something to indicate or rise to the level of to rebut that presumption.
I'm asking this court to look at all that happened. You know, the flag was not in isolation.
No. I want you to tell me what in the record can we look to that would indicate that the jury did not follow the judge's instructions. That's what I need.
Mr. Buchanan won.
I'm sorry?
Mr. Buchanan won the case.
But the jury found on that specific question that the investigation of the 2016 incident, I think it wasn't racially motivated. So doesn't that suggest the jury was not swept away by prejudice or emotion?
No, I suggest not. And like I said, I ask you to look at the whole package here.
Why not?
It could mean anything. I've talked to jurors. It could mean, we don't know what they were thinking. What we know is they heard evidence that a police officer had a Confederate flag. They heard evidence that the chief didn't do anything about it, even though that was precluded. They heard evidence that this became a community.
Is it a reasonable inference from their finding on that question that they disregarded the flag?
No.
Why not?
Because the flag was also, they wanted to put it in as a comparator, not just the investigation, but that he didn't investigate the flag, he didn't punish him for the flag. That was excluded. However, the judge allowed in testimony that the flag created a community uproar. That testimony was specifically excluded before, and when Mr. Ryan got into it, I objected. I hate to do it, it's strenuously. I objected, and the judge said in front of the jury, Mr. Kett, it's in evidence. I said, no, it's not. And then he yelled at me for correcting him. It wasn't in evidence. That's how it got put into evidence. If you look at what they heard all this stuff about which imputed the chief's actions, because they said they know nothing happened. So while they didn't get to argue it's a comparator, the jury was told that Chief Haig, who's the prime actor in this thing, did not do anything, that this became a community uproar. All that stuff was ostensibly excluded. However, we never knew what he actually ruled because he wouldn't tell us. If you recall the quote, which I'm suggesting, I guess you've never heard before, it's this trial court judge telling a lawyer that I'm not going to explain my ruling because it'll give you a toehold in the appeals court. And that was the ruling. What are you ruling? What exactly is this going in for? Why is it in? And then they ran with it, and they talked about there's a community uproar. That never should have gone into evidence. The jury hears all this, that there's a community uproar, and they rule against. They were not asked to rule about McCarthy. McCarthy was never sued. There were no questions about McCarthy at all. But they found that the chief having an investigation clearly and punishing him was racist. So how do you unpackage that? How do you unpackage also, if I may, the judge's behavior? I mean, I'm trying to try a case, and I've got a judge who's unhinged. Take a look at when he went off on me about interrupting the witness. If you would read, I went back and read it, because he said it was a buildup. There was no buildup. The witness, the then plaintiff, Todd Dodge, was expanding on every question. I'd ask one question, he'd go on and on. Judge never did anything about it, even though they were all yes or no questions. Finally, as he's going on, I said, "Excuse me," and he goes off on me, starts yelling at me in front of the jury, stalks off the bench, comes back, accuses me of being unethical. And if you've read, I said to him, "Then report me. I'm being unethical?" Then the next day, suddenly I become a very, very highly respected lawyer. He apologizes, so it was really nice. And then in his post-trial filing, in his post-trial decision, he says that I was obstreperous, he had to bring me under control, he didn't mean the apology. This went on through the whole trial. The jury saw it. So you start with that behavior.
The jury didn't see his post-trial decision, though.
No, I'm sorry, the behavior. They saw his faces, they saw his yelling. And frankly, I mean, what I'm upset about, because I have a lot of respect for them, they lied in their brief. In my opening statement, they claimed that I yelled at Todd Dodge. And I am highly offended by that he was in the gallery. Todd Dodge was about 7 feet from you to the jury. I was here closer. I said something, he started doing this, shaking his head, and I said, "Don't shake your head, Todd." And the judge goes off. I'm reprimanding him. I said, "Your Honor," he's shaking his head. He goes, "I don't care." The next day, he comes in and says, "Well, now I care. Had I known he was shaking his head, Mr. Kessler, I would have done something." This is what we dealt with. This is what we dealt with throughout this trial. So it's not just that. When you look at the whole package, everybody in this country is entitled to a fair trial. This has been my life, it's probably been most of your lives. I respect this system. And the judge is supposed to be a neutral referee. And the judge is supposed to know the law. But you see how personalized this became.
So what discretionary rulings or rulings of law do you contend the judge made based on this bias you're alleging that would have been different if he had not been biased?
He demonstrated to the jury hostility towards the defendants by demonstrating hostility towards me. He demonstrated partiality. He allowed in so much of our life in those 4 weeks was devoted to this question of the flag, which we had to deal with, which was evidence which Officer Buchanan got to testify about how much this all hurt him. I'm sure it did. But how does that not infect everything that happened in this case?
I just want to make sure I understand your argument. You're not challenging a particular ruling and saying that some kind of animus or personal animus contributed to it. You're saying that it was the demonstration to the jury of animus that sort of poisoned the jury.
And the flag. I mean, that was
the flag. Ultimately, he ruled. I mean, there were a lot of changing arguments. The judge ultimately ruled and instructed that the evidence should be disregarded. There was no complaint about the efficacy of that instruction that I saw. So I just want to make,
okay.
I want to get clear on what your argument is
We
about
also have the sealed portion. We also have that, which was a very important piece
Before
of
we get
evidence.
there, the judge also instructed the jury not to base their verdict on any like or dislike of counsel and only based on the evidence.
We live in the real world.
I try my best, but
No, you do.
we
So
have to
we all
apply.
do.
We have to apply the law that happens in the real
Yes.
world. And one of them is similar to what I said at the beginning: is that we have to presume that the jury followed those instructions.
And I ask you to, okay, you have that presumption, it's rebuttable. And I ask you to look at the circumstances, the timing, and the devastation of the evidence. And the evidence came in days before. We didn't even get into what they should disregard. Should they disregard the community uproar? And I most certainly objected to his, I said, you can't, this is not curative, as did the plaintiff. As did the plaintiff. It's way too late. You can't unring the bell. To unring the bell is the term used. One of the favorite ones from a case was you can't throw a skunk in the jury box and tell them to ignore it. He did it on the last day. And Justice Sachs, they were not changing arguments. They were not. His decision, which claimed that, he blamed us for inviting error. He came up with cat's paw. He doesn't even know what it means. But he threw that in on April 14th. Suddenly he says it's a cat's paw case. Cat's paw case? Not even close. And we outlined why it isn't. And then to cover himself for what he did in his post-trial motion, he then tells you that it's all because...
If you want to discuss the sealed matter.
Okay, the sealed memo, that evidence should have gone in. That conversation should have gone in. The facts of the conversation, and it's critical to the case because the only person that testified that there was actual racism was that person.
So the judge's conclusion is one of fact, and you would have to show that that was clearly erroneous.
Yes, you would.
Okay.
And it is a fact, and if you, I've only seen it once because there's all these secrets. This transcript is being treated as a national secret. By the way, I never asked for it to be sealed.
No, the plaintiffs did.
No. There was going to be testimony about this conversation, which included some stuff about the personal life of Chief Haig. And I said to the judge, could we clear everybody from the courtroom except for the lawyers for this? That's what I asked for. Without really getting into it, he goes, okay, I'll seal it. I, at that point, didn't think of the import of this, why he would never then reverse it. But that's how it happened. I simply asked people to be clear. There was no discussion. He made no findings. Now that I know about sealing, you're supposed to make findings as to why it should be. He made no, he just did it. And then afterwards, when the mayor wanted to do an investigation, the judge refused to release a transcript because Lieutenant Dodd said, they're trying to harm me.
Okay, we're going to have to leave it there, Mr. Keston. Thank you.
Thank you. It's always a pleasure.
Mr. Ryan.
Good morning, Your Honors. Timothy Ryan for the plaintiff. I'm joined by co-counsel Michael McDonough. Also with us today is our client, former Greenfield police officer Patrick Buchanan. Your Honors, we would ask that the court deny the defendant's appeal, affirm the jury verdict in Mr. Buchanan's favor. In the unfortunate and likely event that you were to not do that, we'd ask that you consider our cross appeal on the issue of the flag. The standard of review on appeal is abuse of discretion. There was no abuse of discretion.
I mean, you had a pretty good case without the flag, didn't you? I mean, that seemed to be an unnecessary diversion.
Well, no, Your Honor, no. The defendant chose to have Mr. McCarthy, Sergeant McCarthy, as an evaluator in the second process in which Buchanan was again bypassed 4 times for promotion. They put into evidence 6 internal affairs reports issued by Sergeant McCarthy against Patrick Buchanan, in which Buchanan did such awful things as accepting a stick of gum from a construction work on a road job or appearing for his shift at the time the shift was called. Sergeant McCarthy was present when Detective Clark was repeatedly drunk on the job and didn't put a pen to paper.
So McCarthy's not a decision maker, though.
McCarthy was an evaluator, Your Honor.
Right. So did you plead this as a cat's paw case?
I don't see it as a cat's paw case because
the judge did.
to have cat's paw...
I'm sorry. Doesn't the judge conclude at the end that it's a cat's paw case?
To keep it out. To keep it out. But it's not a cat's paw case because the premise of a cat's paw case is that there's an innocent dupe. The chief said when
They have to be innocent.
that there's a dupe who's not motivated by racial bias.
The chief is not harboring racial animus, but McCarthy's driving the bus with his behavior.
The jury verdict shows that the chief, in fact, was harboring racial animus. Further, when Buchanan's at the top of the list to say he's lazy and doesn't fit the bill. And we had 2 senior officers who said that, both the deputy chief and Sergeant Dodge. And he instructed Dodge, see what you can do to get around the civil service with Buchanan at the top of the list. That's in the autumn of 2014. January 15, 2015, they promote him to provisional sergeant. January 21, 2015. 6 days later, they put him out on administrative leave, and on the 28th, they demote and suspend him. There's racial animus there, Your Honor. Particularly when compared to what they didn't do with Sergeant Rode, who was involved in a fatal. They allowed him to get 111F benefits, tax-free for 16 months. Nothing with respect to Sergeant or Detective Clark.
Was Mr. Buchanan's civil service scores higher than the white comparators before they changed the system?
He was at the top of the shortlist, Your Honor, in 2014, and they chose, well, they promoted him for the provisional, because you have to, because he's the senior guy and he would accept it, and then they quickly they exited him out by the end of the month. 2 weeks in that position.
But were there were other promotions or passover for promotion, I'd say. Did the white comparators score better?
So then they wanted to go around civil service, so they went to a assessment center, and Patrick wound up number 3 by a point. And they took the top 2. And in 2020, when they do it...
How many positions were available then?
So in 2015, Your Honor, there were 2 promotions. Sergeant Rode, who didn't pass the civil service, and Sergeant Haskins, who was behind Patrick on that short civil service list. And so they rejuggle it, and they come back with 2 white officers, and that list was satisfactory to the town of Greenfield and to the police chief.
So the
list with Patrick at the top was not.
I just want to make sure I understand. So the change in process.
They changed the process.
Not the raw numbers. The change in process is where the racial animus was harbored.
The fact that they didn't promote Patrick off a short list, having just done that for a white officer months before. It was March, I believe, of 2014, they promoted Sergeant Westerling, or Officer Westerling to Sergeant, and Patrick's, that list comes in the fall of 2014 and doesn't fit the bill.
If Buchanan is 3rd, and there are 2 positions open, and they appoint 1 and 2, where's the racial animus there?
The racial animus, Your Honor, was in the refusing to do with Patrick Buchanan what they did with Officer Westerling, using a short list. And so they changed the process.
Okay, now you've answered the question I asked before, which I probably posed poorly, but thank you.
Or I'm hearing poorly, Your Honor. But
let me just ask you this, because I'm still wrestling with the flag issue, because it does seem to have been irrelevant and prejudicial, unfairly prejudicial. But you made a good argument. You've made several good arguments to say, well, there's no prejudice from it. And one of them was, well, one of the questions that the jury answered with regard to that traffic stop involving the officer who started the ball rolling in all of this, in that case, they said, did the plaintiff prove that the chief initiated the internal investigation because of racial animus? No.
Correct.
Well, that seems to be pretty good answer in your favor. But the next question, question 4, did the plaintiff prove by a preponderance of the evidence that the 3-day suspension that the chief imposed as a result of the internal investigation was motivated by racial animus? And the answer to that question is yes. So how do we know that that whole Confederate flag issue and all the evidence surrounding that didn't influence the jury to check that yes box?
because on question 4, Your Honor, what you're looking at is you penalized and disciplined Buchanan with the suspension and the demotion. But we have all of these other things. McCarthy grabbing a kid's phone who had been romantically linked with his daughter. He had no right to do that. The chief calling the hospital to get a nurse fired. He had no right to do that. Clark, who was repeatedly with his weapon, operating under the influence on and off the job, and nothing happened. He's their number one for the second round of promotions. That's where a jury properly says there's a discriminatory impact here, because if these guys are getting away with these heinous events, how can you throw the book at Patrick Buchanan? That's discriminatory, and the jury was proper in making that finding. But again, going back to the Stricker case, I believe it is, the presumption is that the jury follows the court's instructions. The further thing is, the jury was not so inflamed, Your Honor, that they awarded punitive damages, let alone significant punitive damages. So this was a conscientious jury. They were out from Monday to Friday. They were doing their work diligently, dispassionately, and they came back with a modest verdict. I mean, if I had a $10 million punitive damage award, Your Honor, I'd agree that maybe there's some evidence that the jury was inflamed. But these numbers are very reasonable. They're in accordance with the evidence. And the evidence of discrimination is significant, of time and time again passing by Pat, even in the 2020 promotions. The chief scored him a 54. There were 3 people scored below 72. They score Clark at an 80, and they say that Clark and Buchanan have the same scoring with respect to internal discipline. Come on, give me a break. That can't be fair. That's not on the level, and the jury was able to see that. And so there's more than sufficient basis to find. So the chief scores him 54, puts Patrick at 5th place. There were supposed to be 3 promotions, and they take 1, 3, and 4. They pass over a woman at number 2. There's a 4th promotion that comes. Patrick's sitting number 5, and they take the lower-ranking white officer, and the mayor who was there never saw the scores, never knew why they bypassed. So there's just no basis for the appointing authority to articulate why we passed Patrick Buchanan for a lower-ranking white officer.
Let me ask you this other question with regard to the impounded material. So I want to avoid mentioning any names here. So you have an officer who approaches one of the defendants and says words to the effect of, "I know you're not a racist," or something like that. Why can't the defendant, in an effort to defend himself, at least cross-examine this witness on that point? Like, isn't it true, sir, that just moments ago or whatever, the day before, you said this to my client? Why wouldn't that be?
There's no basis on that issue to remand this for a new trial. There's no basis to put everyone through another 4 to 5 weeks of this.
He's a critical witness, though, right?
Sergeant Dodge worked with the chief from 2015 through the end of the case. They were together every day, virtually. And so there's, the idea that this happens at trial, during trial, one, stretches the bounds. Further, the transcript shows that there was a discussion of a settlement demand. The numbers were articulated. So it falls within a settlement discussion that was approved by counsel for Todd Dodge and counsel for the chief. That discussion occurred with the prior approval of counsel. So they can talk anytime they want it otherwise, but this is during the course of the proceeding.
Didn't the judge excluded it because he said that witness was going to deny that he said, "I know you're not a racist"?
I think it was a 408, that it was within the context of a settlement discussion. So whether it's formal mediation, whether it's or not, 408 says that statements made during a settlement discussion are inadmissible. And I believe that the import of the judge's finding was that discussion was in the nature of a settlement discussion.
He did, but what about factual assertions? Can they be segregated? Or denials of factual assertions, I suppose.
Can they be segregated? Anything other than what happened in that conversation, yes, Your Honor. But if it's a statement from that conversation, didn't you say in a settlement conversation A, B, C, and D? That would be inappropriate. And that's what they're trying to say. Well, we should have been able to ask what exactly was said during that settlement negotiation, which the judge properly said, no, that's not going before this jury. Is finding?
We're reviewing for an abuse of discretion.
Yeah, and it's an evidentiary question. He had the colloquy, the closed colloquy in the courtroom. He heard from both parties. He heard from both counsel on that issue. And he made a reasoned decision.
Is the need for this to be sealed, does that remain? I know it's in your brief, the reason why it was, but does it have to remain sealed?
I don't have any objection to it. I think it's more.
I know Mr. Keston doesn't.
Objection to it, no.
All right.
To removing it. Well, we've had a change in leadership in Greenfield, so the former concerns we have are no longer present concerns.
Oh, okay, that's the answer I was looking for. All right.
Thank you, Your Honors. And we'd ask again that you deny the appeal and affirm the jury verdict. Thank you.
Thank you. Thank you both. We'll take it under advisement.
Thank you very much for your attention.
Our last case is 23P1152 CS versus MR. This, as counsel knows, is partially impounded.
Yes, Your Honor.
Ms. Williams.
Thank you. Good morning, members of the panel. Attorney Heather Jo Williams for the appellant. Although I focus on many different areas of the lower court hearing that I believe were a miscarriage of justice, I would like to draw this panel's attention particularly to page 88 of the appendix, which sort of summarizes my arguments in my brief. Although I was not counsel at that hearing, counsel for the appellant did a good job preserving the record. He inquired as to the lower court first inquiring, are you putting the credibility of the two parties based on statements of parties that I can't cross-examine? To which the court responded, yes.
Was there a request to cross-examine them, or was there an objection to the statements coming in because the witnesses weren't present and it was hearsay?
Throughout the proceeding, the lower court attorney, Mr. Pachella, did state that he wanted to cross-examine and he objected.
Where?
Right when they first were introduced. Let me get the page on that. At the beginning of the hearing, there was a discussion between Mr. Pachella, Attorney Pachella, and the lower court justice indicating that he had not yet seen those statements. The court inquires, well, did you come to the court to get the statements? And he said, no, I asked for all the statements. Then when they reconvene, this is on page 41, he asks, this is where the court says, did you come in for the file? He said, no, I talked to the clerk's office.
But I don't see anything about cross-examination there, or I'd like a continuance so I have an opportunity to subpoena them, or any of those types of objections.
So he did not ask to subpoena, but he does raise objection. And again, at the conclusion of the hearing, he's raising the objection that he was not given the opportunity to cross-examine.
Right, where else in the hearing besides page 41 can you point to?
I would have to say, Your Honor, it does not specifically say I'm asking that these statements be stricken or that they be removed from the record. That is not in the lower court record. Those statements were not made. So from a due process perspective, my client was not given the opportunity to cross-examine two out-of-court statements. They were not affidavits. They were not under oath. I recognize that there are relaxed standards of evidence in these types of hearings, but they were letters. And the letters themselves were contradictory to some of the live testimony. Then following and referring back to page 88, moving on to page 89,
I'm not understanding, I mean,
so when
who did the defendant want to cross-examine?
it's the authors of two letters that were provided to the court attached to the affidavit of the party applying for the 258E order, there were two letters.
Okay.
When counsel for the defendant in the lower court case, the appellant in this matter, asked to receive the files to prepare for the hearing, those letters were not provided. He then learned of the letters on the date of hearing. In the hearing, he says to the court, you're putting the credibility of two statements that I can't cross-examine. And the court says, yes. He goes on to say, he asks the court, this is at the top of page 88, he asks, starting on page 87, moving on to 88, the lower court attorney inquires, well, what are you basing this 258E order on? An act that occurred in 2020. And the lower court says not once but twice, I'm issuing this order on the one incident that happened in 2020.
So the definition of harassment includes 3 acts, or it can include a single incident of a sexual assault or forced sexual relations, can't it?
Under the 258E standard, there needs to be 3 specific separate acts. Under 209A standard, which there was some argument that it's not really flushed out in lower court record, which is why I did not focus on that, the defendant was trying to make a case that he actually was in a consensual relationship with the complaining party in 2020, and that the relationship ended in 2020.
I'm looking at the definition of harassment on page 40 of your brief. That's in the addendum. And 258E1, under harassment, little Roman 1, 3 or more acts of willful malicious conduct, or little Roman 2, an act that cause forcible sexual relations or constitutes a violation of a variety of statutes concerning indecent assault and battery, rape, things like that. So why is not a single incident sufficient?
Well, it becomes insufficient when it's being relied upon on the credibility issue. And further, although I recognize—
I'm sorry?
What? I missed that.
There's credibility issues throughout. So it starts with the lower court cites that they're basing the credibility on a he said, she said on that one act. And they're relying on out-of-court statements that at that lower court, my client was not able to cross-examine those individuals, and they weren't even affidavits. And so then when you look at the whole record in—
Get straight. If it were conceded that there were one incident of indecent assault and battery, would that be sufficient to issue an order?
Potentially, but I do think we also run into a problem of the nexus in time, and that this act had to have caused fear or caused intimidation, which the alleged act occurred in 2019 or 2020.
So that's a credibility decision for the judge, whether to believe the complainant that she's in fear.
Correct.
Okay.
And the alleged act occurred in 2019 or 2020. The complainant did not come forward until 2023 to claim something that occurred 3 years prior.
Just so I'm clear, this isn't a statute of limitations.
No, it is
argument.
not.
It's just the credibility of, is she still in fear?
It's a credibility about the fear issue. It's also a matter of, in her own statements, when you compare her affidavit, although it's very slight differences in her wording, and then in her live testimony, when she's referring to that act that allegedly occurred in 2019, she speaks of, in one statement, she says that the defendant pushed her to a couch. In another, so that is the statement that is in her affidavit that you can find on page of the appendix. It's on page 26. She writes that he pushed her to the couch, and then in her live testimony, which is on page 70, she testifies live in front of the judge that, I'm sorry, The live testimony is, he pushed me onto the couch, page 70 appendix. The affidavit that she typed and brought with her to court to seek a 258E was that he guided her to the couch, and that is on page 26. So she also, in her affidavit, while the lower court found her credible, and I recognize that there is, it is within the lower court's purview, she writes, and this is on page 25 of the appendix, that there was an incident that occurred on February 7th of 2023. On cross-examination, she concedes that the incident where she was at a graduation and that the defendant made her uncomfortable actually occurred in January of 2019. So I can recognize on first blush when the lower court is faced with a young lady that comes in, she's complaining about a superior in a police department who is sexually harassing her, who's making her feel intimidated, who she believes is in a position of power and control, and puts a 5-page affidavit supported by 2 letters of
But
other...
it's more than that, not just harassment, but he sexually assaulted her.
That's what she's saying 3 years later.
Wow.
I recognize that. But for 3 years, she worked with this gentleman. We have the emails. She also, in her testimony, she can't remember if she sent the emails. In one statement, it sounds like something she would say, but then it sounds like something she wouldn't say, whereas the defendant did not waver in his testimony. This is my email address. That is her email address. These are the emails that I received March 7th of 2020 when our consensual relationship ended. And then they worked together for 3 years until March.
But what do we do with the judge's finding where he specifically found that he credited the plaintiff's testimony and he did not credit the defendant's testimony? What do we do with that?
That's where I've argued that it's a reversible error, because if you look at the totality of the record, there are multiple places where the complaining party, where this young lady, she contradicted herself in her written statements. She contradicted herself in her oral testimony. She contradicted herself in the statements that she presented.
These sound like great arguments to be made to the trial court judge, but once she makes her decision about credibility, even if we don't share her assessment based on our reading of the cold record, what are we authorized to do about it?
Think that there was a gross miscarriage of justice and a misapplication of the law when a lower court judge relies upon an incident that allegedly occurred 3 years prior and the credibility of the statements and doesn't consider what occurred after. And
Can you cite a case where we've reversed a judge's issuance of a 258E or 209A order based on our disagreement with the judge's assessment of the credibility of the witnesses?
No, and I did attempt to find one, but as I do understand the law as it exists, the lower court has broad discretion and it is their job to determine the credibility.
Right, and not just in these kinds of cases.
In all cases.
Right.
But there are cases where they misapply the law, and I believe this is a case where that has occurred. There needs to be a finding that this woman was in fear, and her behaviors and actions for the 3 years following the alleged assault do not match that. And further, and I recognize that at the conclusion of the hearing, the lower court judge makes comment that she does not believe this is a case where an aggrieved party is trying to get someone fired. That was never what the argument was. The argument was that the party that was seeking the order was actually trying to extend her employment. And by making the complaint against her superior, she in fact did achieve that. When she made the complaint and she went to her union rep and all of the allegations started to come out, the plan where she had to finish the academy by April of 2023 changed, and she was given another opportunity to do a different path to retain employment. The argument that the lower court seemed to think was being made by counsel, I didn't even see that being made in the record by the defendant stating, oh, this woman is just trying to get me fired. She's just upset that we had this relationship. That was never the argument. It was that she was trying to extend her employment and that she had not passed the academy on multiple occasions, and she was at the end of the line. And that my client, the appellant, who was her superior, and the impetus that she went to the court and said, I need a harassment order, I need to not be harassed by my superior, was him performing his duty in attempting to obtain back police-issued equipment, a radio, a microphone, and a badge that she didn't want to give back because she believed that was still her job and it was still her equipment, and she wasn't giving it back. And she said, because he was trying to get my badge, my radio, and my microphone, I'm now afraid of him. Where for 3 years, they worked side by side. We've included, and it was part of the lower court record, the text messages that went on for 3 years. very cordial, nothing inappropriate, nothing menacing, nothing fearful, nothing harassing, nothing threatening coming from my client, no statements or fear, no anywhere in the record of their communications for 3 years is there any notion that this woman was afraid of her superior. Nowhere in that record is there a statement of the officer that he was threatening, intimidating, harassing, trying to gain control, trying to harm her employment. It's not in the record. For 3 years, she operated side by side with him in the same department with no issues. It only came to a head, and she only raised allegations from 3 years prior when she was faced with losing her job. And she was faced with losing her job from the chief, not from my client. This came from the chief to my client who said, look, you've got a hand in your radio. She didn't want a hand in the radio. She then tries to make she differentiates to the lower court and says, well, I did hand in my radio. He didn't have to come to my house. Well, she handed in the radio without the microphone, which is the part that makes the radio work and allows you to talk to the other people. I recognize they can mix and match, but it was the whole radio. And she was trying to split hairs on that. And I think that allowing an order like this to continue sets a precedent for a very slippery slope, that someone can allege an incident that occurred 3 years ago, 5 years ago, 10 years ago, and then get along with their neighbor and get along with their coworkers and behave in a manner that to the outside world that there are no issues. And then they become aggrieved about something else, and they want to bring up issues from the distant past, from 3 years prior, and say, this happened and now I want an order. And based on that, I believe this order should be reversed, and I'm requesting that Your Honor take into consideration the arguments, and I would rest on my brief unless there's any further questions.
Seeing none, thank you. Take it under advisement. With that, that'll conclude our session. I want to thank my colleagues, the court staff, the clerk's office, our court officers, and our wonderful timekeeper. With that, we'll stand in recess.
Hold on,